So let's get to our next topic, and this is understanding real estate terms. So it's real estate's been around since the dawn of time. I mean,
well, a lot of the laws that we use in real estate are from Old English law, with the exception of the fact that we own the land as opposed to lease the land from the king.
Yeah, exactly.
But we still pay property taxes.
And that's a very interesting little bit of history. A lot of the terms that we have today and how we do business really comes from like ages ago, England, UK. And so
anybody who watches Game of Thrones or those medieval stuff and they talk about lords, well, that's what those lords became landlords. You know, before it would be like you own and control everything from here to the eye can see. Now we have parcels. So things have evolved.
Yeah. So there's a few terms that some people have. They don't quite understand it, and we're coming from a public perspective. The public doesn't understand some of these terms, and so we just want to briefly cover them. Term number one is agency. It's amazing how many people don't understand agency. You want to break that down? Well,
essentially in layman terms, it's who works for who. Are you the buyer's agent, and are you working in behalf of the buyer versus you're working in behalf of the seller? Or a lot of times when you're thinking about legal matters, and one side, a plaintiff, will have a lawyer representing them, and a defendant will have a lawyer representing them. It really just delineates who's taking care of what and what each person's responsibility is to the client, which actually segues really nicely into the next word, fiduciary.
So a fiduciary is someone that has to act at any cost in your best interest. They cannot put their own self-interest I learned something the other day. There's another term and I'm blanking on it, but it's not their self-interest, but putting aside your own interest.
Yes.
Yeah. But anyway, they can't do that. A fiduciary has to act in your best interest at any given time, which makes California real estate very unique with brokers and real estate agents that you don't find in some other states.
Right. Now, when you think of the word fiduciary, too, and acting on behalf of somebody else, that word usually applies to attorneys and doctors, right? So attorneys, you'll always hear this all the time, attorney-client privilege. So you're only going to disclose what you're allowed to disclose, and certain things are completely confidential when you're an attorney. Well, those same types of legalities or responsibilities to a party, to another party, apply to realtors in California. But as Marc said, in other states where real estate agents don't act as attorneys, whereby they write contracts or give advice, they simply are professional space showers. And
now, one thing to point out is that in California, licensed real estate agents and brokers are not allowed to actually write contracts. They're only allowed to fill in spots on a pre-created contract. Very interesting fact, that isn't it?
Yeah, that's supposed to be true, but then you get into other aspects of real estate where we don't even use the pre-filled contracts that everybody's accustomed to, like either AIR or California Association of Realtors. But there's a method by which attorneys use where they use editable Word documents, and then they will definitely, instead of just giving a counter proposal or an addendum, they will redline specific areas so they can show the changes and then date stamps by which certain terms that were set forth in writing were now stricken out. And so in that essence, you actually are not just filling in blanks, you are actually filling in aspects of the contract. But yes, so it's one of those really weird things where a lot of times attorneys will typically accuse California real estate agents of illegally practicing law without a law license.
Now, the next term is dual representation, which a lot of people get confused with this, including brokers themselves and real estate agents. So dual representation, the way it's defined here in California, is any broker representing multiple clients on a transaction. So they could be representing the buyer and they could be representing the seller. Now, if it's two different agents, but under the same broker, it's still considered dual representation. That's where a lot of the confusion comes into play, because you will have people or one agent say, well, I'm representing the buyer, and you have another agent from the same company saying, well, I'm representing the seller. But legally, that broker who oversees both of those agents has a dual representation to both of the clients.
Yeah, little fun fact, in Florida, dual representation is actually illegal. You're not allowed to do that. And Florida is probably more litigious than California is. So the amount, I used to have a broker's license in Florida. I let it expire 10 years ago because I wasn't using it anymore. But it's illegal to have dual representation in Florida, whereas in California it's perfectly legal, provided that you have certain disclosures and you have a lot more, you have a greater fiduciary responsibility to both parties in that instance.